ಲೈಕ್ ಮಾಡಿದ್ರೆ ವಿಡಿಯೋನ ಚಲೋ and ask me if you have any doubts. Definitely comment box is open. You can ask me anything if you have related to. So bacho, in the last class definitely we have covered so many part, right? Agreement, revocation is also done. Okay, this is also done. Okay, this is also done completely. Yesterday we have done this, right? Now start guys, let's start a description, consideration. What exactly the consideration is. Hi Archana, regular ಹಿಂಗೆ class
Hello.
daily.
Hello.
ಹಾ ಹೇಳಮ್ಮ.
Sir, voice ಕೇಳಿಸತ್ತಿಲ್ಲ sir.
ಒಂದ್ ನಿಮಿಷ
Hello.
ಒಂದ್ ನಿಮಿಷ Can you hear me now?
ಹಾ yes sir.
ಚಲೋ ಡೈಲಿ ಕ್ಲಾಸಸ್ಗೆ ಬನ್ನಿ. ಡೆಫಿನೆಟ್ಲಿ ಡೌಟ್ ಇದ್ರೆ ಕೇಳ್ರಿ, ಓಕೆನಾ? ನೋಡಿ, ನಾನು ಕ್ವಶನ್ಸ್ ಡಿಸ್ಕಸ್ ಮಾಡ್ತಿದ್ದೆ. ಈಗ ಲೈವ್ ಬಂದ್ರೆ ಏನಾಗುತ್ತೆ, ದಿಸ್ ವಿಡಿಯೋ ಗೆಟ್ ರೆಕಾರ್ಡೆಡ್. ಈಗ ನೀವು ಲೈವ್ ಬರಲಿಲ್ಲ ಅಂದ್ರೆ ವಿಡಿಯೋ ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ ಸರ್ವರ್ದಲ್ಲಿ, ಮತ್ತೆ ಯೂಟ್ಯೂಬಲ್ಲಿ ಇರುತ್ತೆ. ಅದಕ್ಕೆ ದಟ್ಸ್ ವಾಟ್ ಐ ವಾಸ್ ಸಜೆಸ್ಟೆಡ್ ಟು ಜಾಯಿನ್ ಲೈವ್ ಕ್ಲಾಸಸ್ ಬಿಕಾಸ್ ಲಾದು ಇಂಡಿಯನ್ ಕಾಂಟ್ರಾಕ್ಟ್ ಆಕ್ಟ್ in the same time remaining all will finish bacha. ठीक है, don't go anywhere. Next 1 hour we'll discuss all about your contract now. ठीक है, doubt ಇದ್ರೆ ಕೇಳ್ರಿ. ನೋಡಿ, ಇದು ಕ್ವಶನ್ ಭಾಳ ರಿಪೀಟ್ ಮಾಡಿದ್ದಾರೆ. 2019 November 19 and yeah, this is a very important question my dear student. So बच्चों, define consideration. State its characteristics of valid consideration. Very important, they want valid consideration bacha. Valid consideration. So now the very important point, what exactly the consideration? Consideration is nothing but something in return, correct? Something in return, pratiphala anta ಹೇಳ್ತೇವಲ್ಲ, right? So what we can say that as per the section 2 subsection D of the Indian Contract Act 1872, sections ಬರಿಬಹುದು. ಇಲ್ಲಾಂದ್ರೆ as per the Indian Contract Act 1872 consideration has been defined as, hearing, when desire, at the desire of the promiser, remember, at the desire of the promiser, promisee or any other person has done, very important, has done or abstain, has done or does or abstain from doing promises to do something, from doing something, such act or abstences or promises is called consideration. Sir, hinga baribekendri sir? Yes, we have to write like this way only. Correct. Ega bachcho, the essential characteristics of consideration. See, there is something called valid consideration. What is the valid consideration? Consideration that is accepted. This is the something should be in return, pratiphala antaralla. So consideration must move at the desire of the promiser. See, at the desire of the promiser, the consideration must move, right? So consideration must be offered by promise or any either a third party at the request of the promiser. Very important. Any act, ಯಾವುದೇ ತರದ act, any act done at the desire of the third party is not consideration at all. See what they say, consideration must be offered by the promise or any either third party at the request of promiser. Any act done by third party is not at all a consideration. Say A saves S goods from the fire without being asked by S. Now A cannot claim a remuneration from S for saving his goods, right? Because he has not promised to A saying that I will pay you this much goods, this much dudu. Getting a point? Getting a point? So this is the first consideration must move at the desire of the promiser. Means you should have some kind of promises from other party that they are going to pay, they are going to give something in return, right? Second, it may proceed from promise, it may proceed from promisee, the person who has proposed, or any other person on his behalf. Say, assume that A and B, he is a promiser, he is a promisee, and he is given the proposal. For that, he is accepted. In return, what he has to do, he is a promisee, he has to give some consideration for his goods and whatever the promise is. The definition of a consideration make it clear that consideration may move from promise or any other third party when I desire the promiser, the promise or any other third party does any act is valid. Very important. Thus, there can be stranger to the consideration but not stranger to the contract. Very important. Very important. Stranger to the consideration, not to stranger to the contract. This is because from the third party you can expect some consideration. That is what. But when desire the promiser or promise or any other third party does any act is valid. So what we can say, a stranger. So there can be a stranger to the consideration, but stranger to the contract is not there. अर्थ ಆಗಿದೆಯಾ? अर्थ ಆಗಿದೆ? Understood बच्चों? Understood? Next question. Next ನೋಡಿ, it may be executed ಅಥವಾ executory. We have discussed ಮಾಡಿದ್ವಿ ನಾವು. Consideration ತಲ್ಲ executed ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀವಿ, दे दिया उन लोगों ने, देना बाकी है, ಕೊಡಬೇಕಾಗಿದೆ, right? So consideration which is consist of an act which is already performed, they have done it, is executed. When the consideration consists of only a mutual exchange of the promissory, means future they may be, future dalli avaru kodಬಹುದು, that is called as a executory, right? Right bachcho? Next, consideration may be past. Yes sir, understood. So I want to go with the fast forwarding revision now. Consideration may be past, present, future. So guys, consideration may be past, present or future. Please read that. I'll explain now. So bachcho, in the definition only we say that consideration, past consideration to be valid consideration, past consideration must move by the previous request. The main principle, general principle for consideration is given and accepted in exchange. Hence, subsequent promise can never be real consideration for subsequent promise. For subsequent promise, there cannot be a subsequent consideration, so that it cannot be real. However, in the case of services rendered in the past at the request of the promiser, then the subsequent promise for such shall act be valid consideration. See, in the past, you have taken some kind of services, so they have done their consideration. For that, if they are expecting some kind of fees or return, that can be a valid consideration. अर्थ ಆಗಿದೆಯಾ? अर्थ ಆಗಿದೆ? So A does the work for B at a B's desire. After 10 days, B is make promise to A to compensate A for the services, right? Services he has rendered. Such past consideration shall be valid and A can sue B if B does not get consideration. अर्थ ಆಗಿದೆಯಾ? अर्थ ಆಗಿದೆ? पुष्पलता, प्रियंका, अर्चना, प्लीज से यस सर. बच्चों बताओ बताओ, समझ में आया? अर्थ ಆಗಿದೆಯಾ? Next, consideration need not be adequate. Consideration need not be adequate any particular value nor approximate value with the promise for which exchange. It should be, however, be some value. Something in return needs to be equal to something is given. Very important. Something is returned should be equals to something is given. Return should be equal to given. Got it? Got it, बच्चों? No doubt? No doubt? चलो, perfect. Ega, performance. This is done. Performance of what one is legally bound to perform. Very important. This is another important feature of consideration. The performance of the act by person which he is already legally bound to cannot consideration, right? Cannot be a consideration. That means, bacho, what this says, performance of what one is legally bound to perform. Very important. The performance of the act by a person which he is already legally bound to do. Some kind of act he has to do. He may have to sell, he may have to give services, he may have to transfer the exchange of the ownership, right? Bond to do cannot be consideration of the contract. So promise to pay, remember, promise to pay a witness is a void. Remember, if you are paying any amount, so the promise is void. However, if a person is not legally bound to do something and agree to do, then it is consideration paid for, you shall be valid now. See, some kind of illegal activity, if you are paying consideration, is not there, but right, so something and agree to do it, then consideration to be paid shall be valid now. So agreed, see, if you are ready to pay, promise to pay a witness, false witness, it's void, right? Contract itself is a void here. If the contract itself is a void, obviously consideration cannot be considered here. Consideration must be real and not illusionary. Understood? Chalo bachcho, we'll go for the next question now. To form a valid contract. अर्थ ಆಗಿದೆಯಾ? Any point you want me to explain, bachcho? Tell me. Archana, Pushpa, Priyanka. Any point want me to explain now? ಇದರಲ್ಲಿ ಯಾವ್ದಾರ ಪಾಯಿಂಟ್ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಬೇಕಾ? ಹೇಳ್ರಿಮ್ಮ. You want me to explain Kannada? Tell me, explain ಮಾಡ್ರಿ, ಹೇಳ್ರಿ. Is I am fast because we are just going with the fast forwarding division, right? Contract account, Indian contract account, ಮತ್ತೆ ಸೇಲ್ ಆಫ್ ದಿ ಗೂಡ್ಸ್ ಅಕೌಂಟ್, ಪಾರ್ಟ್ನರ್ಶಿಪ್ ಎಲ್ಲ ಮುಗಿಸ್ಬೇಕಾಗುತ್ತೆ. ಬೇಗ ಬೇಗ ಹೇಳ್ರಿ. Understood? Now, to form a valid contract, to form a valid contract, consideration must be adequate. Comment. Bacho, this question you can expect for your exams, bacho. See, they said, right, what they have said, consideration need not be adequate, but what they said, something in return needs to equals to something in given. Correct? So, adequate consideration, what about this? Guys, listen. The law provides that contract should be supported by the consideration. Always. Any contract should be supported with consideration. Correct? Correct. So, as long as consideration exists, the court are not concerned to its adequates. As long as consideration is exists, court will be silent. Yes, there is some consideration. Either adequacy should be depends, provided it is to be some value. Provided some value. What I'm saying that return should be is equal to given. Remember, return should be is equal to given. The adequacy of the consideration, the value of the consideration should be depend on its adequacy is for the parties considered at the time of making the agreement. Agreement ಮಾಡುವಾಗ ನೀವು ಎಷ್ಟಕ್ಕೆ ಅಗ್ರಿ ಆಗಿದ್ರಿ ಅದು ಕನ್ಸಿಡರೇಷನ್ ಇರುತ್ತೆ. Got it? Understood? Understood, bacho? That means court will be silent if there is something is given, something is written, and something is receiving and giving, then court will silent. But bacho, so again, adequacy provided it is some value. The adequacy of the consideration for the party is considered at a time of making the agreement, not for the court when it is sought to be enforced. See, assume that if there are two parties A and B, they have agreed to sell some product for 1 lakh. Now A is demanding from B to pay 10 lakh. In the court will say no. At the time of agreement, what is the value you have agreed? That is what is some consideration here. Understood? So consideration must, however, be something to which the law attaches. Something to which the law attaches. Value, though it is not be equivalent to its value of the promise made. It's not necessary. It should be value equivalent to the promise made. अर्थ आगे point though. This paragraph you understood, बच्चों? You can write it accordingly. Very simple and straight way. Right? Sir, next is what? So, bachcho, what they said is that, what is that? And you can see the consideration for the party is to consider at the time of making the agreement. Now, an agreement to which consent of the promiser is freely given is not void. The consent is given, and in the agreement, whatever the amount, whatever the value, whatever the returns, right, it's not void. Merely because consideration is inadequate, but the adequacy of the consideration may be taken into account by the court in determining the question whether the consent of the promise was freely given or not. See, what they wanted to try to say is that, assume that, bachcho, if there is an agreement, in the agreement, some property they have sold for 10,000, right? And if the parties agreed, there are two parties here, party 1 and party 2, party A and B, and these parties agreed. Court will check whether this person has free consent or not. If his consent is taken by undue influence, in that case, court will think, हाँ, ये तप्पाಗಿದೆ, गलत हुआ करके, right? गलत तप्पाಗಿದೆ ಅಂತ. So that is what we are trying to say, my dear student. An agreement to which consent of the promiser is freely given, right, is not a void, merely because the consideration is inadequate. Merely because consideration is inadequate and his consent is freely given means gone. Everything is okay. If his consent is not free, court will be get into involved in it. Understood, bacha? Understood? So that is what about the form of valid consideration contract. Consideration must be adequate. Arthagidiyam. What we can write is that, what we can write is that, first of all, if the consent of the party is free, if the consent of the party is free, adequacy is not sufficient here, not need to be proved. But if the consent is not free, again the consideration is taken into account here. Understood? Understood, bachcho? Any doubts you have? Hedama? No doubt? Tell me, guys. Now, Mr. Balwant, an old man, by registered deed of gift, granted certain land property to Miss Reena, his daughter. Okay, his daughter. Balwant is an old man. He has gifted his property to his daughter. By the terms of the deed, in the deed they say it was stipulated that annuity of 20,000 should be paid every year to Mr. Sawant, who was brother of Balwant, means uncle of Reena, means his brother should get, Balwant's brother should get 20,000 every year out of the property. Right? Now, on the same day, Miss Reena made the promise to Mr. Sawant and executed in his favor an agreement to give an effect to the stipulation. Whatever the conditions they have said, that she has agreed for it. She has agreed for it. Now, Miss Reena fails to pay the stipulated amount, the condition amount, right? Condition sum. In an action against her, Mr. Sawant, who is a brother of Balwant, right? She contended that since Sawant had not furnished any consideration, she is expecting consideration. She is telling that, why should I pay when I am not getting anything returns from this 20,000? Right? He has no right of action. Examine the provision of the Indian Contract Act 1872. Decide whether the contention of the Reena is valid. No, bacha, no, it is not valid. Why? Bacho, consideration as defined when at the desire of the promiser, the person who is transferring the property. The right, the promise or any other person does any something such an act is consideration. First, you have to write this much. In the light of the definition, consideration may proceed from promise or any other person. Remember, any other person who is not a party to the contract, because here that Balwant and his daughter is a party to the contract, but Savant is not a party to the contract, but yes, he is liable for get the permission consideration here. How they allow? In other words, there can be a stranger to a consideration, but not a stranger to a contract. Got it? Got it, bacho? Got it? So in the given problem, Mr. Balwant has made a registered gift deed in favor of Rima for some property on the condition that she would pay annually to Mr. Savant. Mr. Savant has not given any consideration to Mr. Rima, but consideration did not flow from Balwant to Rima. Such consideration from third party is sufficient to enforce the promise of Mr. Rima to pay annuity amount of 2,000. So thus a stranger to the contract, cannot enforce contract, but a stranger to the consideration may enforce it. Hence, contention of the Rima is not valid. ಅರ್ಥ ಆಗಿದೆಯಾ? Understood ಬಚ್ಚೋ? ಅರ್ಥ ಆಗಿದೆಯಾ? ಬೇಗ 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 ಹೇಳ್ರಿ. Tell me guys. Understood बच्चों? Understood? You want me to explain anything? Is that clear? Is that clear? Tell me, it's a very important. Stranger to the consideration, a stranger cannot do a contract. Please say yes sir. Mundoguna, Archana, Pujari, Priyanka, Pushpa. No doubt bacha? Chalo. So these are the questions you can expect for your final exam. A stranger to the contract, remember, cannot sue. However, in some case, even a stranger to the contract may enforce the consideration. Explain. RDP. Or only a person who is a party to the contract can sue on it. Explain the statement and describe the exception. Yes. Listen. Hand raise madama. Hand raise madu. Bega. Hand raise madama please. ಇದನ್ನ PDF share ಮಾಡ್ತೀನಿ, ದಯವಿಟ್ಟು ನೋಡ್ಕೊಡ್ರಿ ಅದನ್ನ. Tell me ಬಚ್ಚಾ, what is that?
Hello.
ಹಾ ಹೇಳು.
ಸರ್ ಅದು ಪ್ರೀವಿಯಸ್ ಇಯರ್ ಪ್ರಾಬ್ಲಮ್ ಹೇಳಿದ್ರಲ್ಲ ಸರ್, ಅದು ಜಸ್ಟ್ ಇನ್ನೊಮ್ಮೆ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೇಕು.
ಏನಮ್ಮ?
ಜಸ್ಟ್ ಇವಾಗ ಹೇಳಿದ್ರಲ್ಲ ಸರ್, ಇನ್ನೊಂದು ಪ್ರಾಬ್ಲಮ್ ಪ್ರೀವಿಯಸ್, ಅದೊಂದು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡ್ಬೇಕಿತ್ತು.
ಇದರಲ್ಲಿ
ಹಾ ಸರ್,
ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಹೇಳಿ ನಿಮಗೆ? ಹಾ, ಇಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಕೇಳು. Have a look here. There are two parties here, A and B. Okay? And they have an agreement, and this is the promisor and promisee. A has some land here. Okay? He has gifted this land to B. Condition is that B has to give C every month 20,000. Okay? Every month 20,000. All right bacha? All right. So now later B said, I will not pay any 20,000 to him because she is not getting any consideration. One thing you remember bacha, here contract itself says that, right? What it says, stranger to the contract cannot be enforced. See, in this agreement C cannot have a participation, but in terms of taking consideration, In terms of taking consideration, stranger can enforce it. They can claim it. अर्थ ಆಗಿದೆಯಾ? Hi Kishore. Hi Lingesh. Getting a point. Getting a point. So, bacha, a stranger to the contract cannot enforce to the contract, but a stranger to the consideration definitely may enforce it because agreement ಆಗಿತ್ತಲ್ರೋ. In agreement, here what I can say that what we have seen is that Balwant has put a stipulation, condition. What is the condition? Rima has to pay him 20,000 a year. On that ground only he is gifting his property, right? ಹೌದಲ್ಲ, ಕಾಂಟ್ರಾಕ್ಟ್ ದಲ್ಲಿ ಸ್ಟ್ರೇಂಜರ್ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಗಿಲ್ಲ, ಬಟ್ ಕನ್ಸಿಡರೇಷನ್ ದಲ್ಲಿ ಬರ್ತಾನೆ. ಓಕೆನಾ? ಅರ್ಥ ಆಗಿದೆಯಾ? ಹೇಳಮ್ಮ. ಈಗ ಲೆಟ್ಸ್ ಸ್ಟಾರ್ಟ್ ನೆಕ್ಸ್ಟ್ ನೌ. ನೋಡಿ, a stranger to the contract cannot sue. ನೋಡಿ, ಅದಕ್ಕೆ ಸೇಮ್ ಥಿಂಗ್ ವಿ ಹ್ಯಾವ್ ಕಂಟಿನ್ಯೂಡ್ ಹಿಯರ್. ಪ್ಲೀಸ್ ಹ್ಯಾವ್ ಅ ಲುಕ್. A stranger to the contract cannot sue. However, in some cases, even a stranger to the contract may enforce consideration. RTP 18. Only a person who is party to the contract can sue. Only a person who is party to the contract can sue, but stranger cannot sue. But a stranger, third person, can claim the enforceability. How, sir? Look at that. Doctrine of privity of contract of states that doctrine of privity of contract states that only party to the contract can sue here, right? Sue means what? Sue means they are going to claim it. One second. Right? So, and can be sued. Third party cannot sue, cannot enforce if contract is entered between two parties which is later breached. The other party to the contract has a right to enforce it. This contract, that is, sue the other party, but third party again here cannot enforce the same contract. This rule is, however, subject to certain exceptions. Means, in a contract, only parties can sue on each other if they are not getting the consideration. But this rule is there, right? This rule is subject to exception. Exception in certain cases. Why? Even a stranger to a contract may enforce a claim. Only he can claim in the following cases. Remember, bacho, he can claim in the following cases. What is that? In case of trust, in case of family settlement, in case of marriages, in case of assignment of the contract, acknowledgement to estoppel, in case of sudden running covenant running up with the land, contract entered through the agent, right? So these all 7 cases where a stranger to the contract enforce the claim. Enforce the claim means he can ask for the damages. Henge sir, ಸ್ವಲ್ಪ ಕೇಳ್ರಿ. ಈಗ ಟ್ರಸ್ಟ್, in case of the trust. So bacho, a beneficiary can enforce his right under the trust though he was not a party to the contract between settler and trustee. Yes or no? See, who is the beneficiary? In a trust there are so many members they have, right? They get some kind of benefit from the trust. In that case, they can enforce, they have a right to enforce the benefits they are going to get, the claim amount, right? The services, though they are not party in the contract between settler and trustee. Howdo illa? Yes or no? Second, in case of family settlement, bacho, in case of family settlement, if the terms of the settlements are reduced into writing, the member of the family who are originally had not been party to settlement may enforce the agreement. Yes or no? ಹೌದು ಇಲ್ಲ? ನೋಡಿ, ಇದು ಸಿಂಪಲ್ ಇದೆ. ಫ್ಯಾಮಿಲಿ ಸೆಟಲ್ಮೆಂಟ್ ದಾಗ ಇದು ಟರ್ಮ್ಸ್ ಅಂಡ್ ಕಂಡೀಷನ್, ಟರ್ಮ್ಸ್ ಆಫ್ ಸೆಟಲ್ಮೆಂಟ್ ಏನಪ್ಪಾ ಅಂದ್ರೆ reduce into writing. The member of the family who is originally not in the contract, they can claim their enforceability. Understood? Next, in case of certain marriages contract or arrangement, a provision may be made for the benefit of the person. A provision may be made for the benefit of the person. The person may be enforce the agreement though he is not a party to the agreement. Obviously, in case of marriage agreement, it takes place. In case of assignment of the contract, remember बच्चों, in case of assignment of the contract, when the benefit under the contract had been assigned, the assignee can enforce the contract, because even though they are not part of the contract, here also they can assign it. Next, acknowledgement or estoppel, where the promiser by his conduct agreed himself as agent of the third party, it would be result into binding the obligation toward third party in case of consignment, consignor and consignee. Next, in case of covenant running with the land, the person who purchased the land with the notice that the owner of the land is bound to certain duties affected by the land. The covenant affected the land, right? Bacho, the covenant affected land may be enforced by the successor of the seller. That is also there. So next, contract entered into through agent. Say that is also possible if the company is operating. The main person, the owner, principal can enforce the contract. In spite of that, agent has entered into the contract. Correct. The principal can enforce the contract entered by his agent, where the agent has acted within the scope of the authority and name of the principal. So that is also, these are the 7 cases where a third person, a stranger, remember bacho, a stranger can enforce the claim, right? This question ಕೇಳಬಹುದು ನೋಡಿ. ಇದು ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡೋಣ್ರಿಪ್ಪ ನಾನು. I've explained this in detail, ಕನ್ನಡದಾಗ ಎಕ್ಸ್ಪ್ಲೇನ್ ಮಾಡಿದೀನಿ. ಪ್ಲೀಸ್ ಚೆಕ್ ಮಾಡ್ಕೊಡ್ರಿ ಹೋಗಿ. Next, okay bachcho, next question we have. Mr. Sohan Lal sold 10 acres of his agriculture land to Mohan Lal, okay, on 25th September 18, for how much? 20 lakh. This is the consideration here, right? The property paper mentioned in the condition that, yeah, so property paper mentioned the condition that amongst the other details that whoever purchased the land is free to use 9 acre. Out of this 10 acre, he can use only 9 acre as per his choice. But remaining 1 acre has to be allowed to use by Chote Lal, because he is a stranger to the contract, but he can enforce it. Chote Lal, a son of the seller, Sohan Lal's son is Chote Lal here. See, agreement has taken for 10 acre. Out of this 10 acre, only 9 acre is allowed to use whatever they wish, and 1 acre they have to leave it for the Sohan Lal's son Chote Lal, right? Carrying out the farming or other activity of his choice. Chote Lal, the son of seller, for carrying, what he is doing now? He is doing the farming or any activity of his choice. Now, on 12th October 18, because agreement has done on October, Mr. Sohan Lal died. Suddenly he has died, leaving behind his son and life. On 15th October 2018, purchaser, who is purchaser here? Mohan, started construction of auditorium on the whole of the 10 acre. Yes. So, bachcho, third person is stranger to the contract, right? Can enforce the claim. Start here. Who is the stranger here? Stranger is Chote Lal, right? Who is the stranger, bacha? Stranger is Chote Lal, and denied any land to the son. Now, Mr. Chote Lal, who is the son of Sohan Lal, want to file a case against the purchaser, that is Mohan Lal, and get suitable redresses. Discuss above in the light of provision of Indian Contract Act 1872 and decide upon Mr. Chote Lal's plan of action. Definitely, bacho. Does he get valid claim? Yes, he is valid, because he, even though in agreement itself they have said, right, in agreement between Sohan Lal and who is that? Sohan Lal and Mohan Lal, they have agreed out of 10 acre, only 9 acres should be used. Remaining 1 acre has to be left, kept aside. So now, what as per the provision of Indian Contract Act 1872 says, kid, a contract can be enforced by parties to the contract, and third party, our Chote Lal, cannot enforce such contract. Though consideration can be provided by third party. Remember, a third party cannot enforce the contract, but they can enforce the claim. However, बच्चों, there are certain exception to this rule. One such exception is in this case of covenant running with the land. Remember, covenant running the land. Got it? Covenant running in the land is what, my dear student, I'm talking about in the case of covenant running in the land, where the person who purchased the land with notice that the owner of the land is bound certain duties affecting the land. The covenant affecting the land may enforced by successor of the seller. You got it? You got it? In such case, if the buyer purchases a land, remember, my dear student, if the buyer purchases a land which he knows is subject to certain condition, the successor, who is successor here? Sohan Lal, Chote Lal, successor of the seller can enforce such contract. Now, in the above case, Sohan Lal sold his land to Mohan Lal. The contract had a condition that Mohan Lal could use only 9 acres of land for any purpose, but remaining 1 acre of the land shall be used by seller's son Sohan Lal. Mohan Lal used the entire land for construction of auditorium, correct? And refused the land to the son Chote Lal. As this is a covenant running with the land, Chote Lal being the successor, can enforce the contract and get the land even though he had no contract with the Mohan Lal. So hence, Chote Lal is entitled to file a petition against Mohan Lal for execution of contract. Understood? Understood, my dear awesome student? Understood, bachcho? Tell me fast. Any doubts you have? No doubt, right? Guys, those who are watching on the YouTube, like Madri, share and subscribe. Daily classes will be there. Economics, accounts will start. Business law, daily live classes, but complete Indian Contract Act. In this way, we have to explain Indian Contract Act, Sale of the Goods Act, Partnership, Companies Act. Everything will finish. Join again daily classes. Ke. All right, bacho. Next. Till here, understood, bacho? Tell me fast. Everyone say yes, sir. Understood, sir. Tell me, guys. पुष्पा, अर्चना, प्रियंका, बच्चों समझ में आया? लिंगेश, कौशिक, and those who are watching on the YouTube, please mention your name. Understood, right? Okay, next होगा ना? Okay. No consideration, no contract. Comment. RTP. State exception to the rule. Agreement without consideration is void. Same. What do you understand by the term consideration? What do you understand by the term consideration? Are there any situations, circumstances under which a contract under provision of the Indian Contract Act without consideration is valid? Explain. So, but all three are same question. See, now RTP November 19, Jan 21, right? May 22 and May 19, May 2. All are very, very important, bacho. No consideration, no contract. Comment. You got it? You got it, bacho? Chalo. Now, listen, the very important point. What we have to say is that we have to explain this because you may get these questions for sure, my dear student. What is that, my dear student? See, bacho, no consideration, no contract. No consideration, no contract. See, remember, all the agreements to be enforceable by the law must be supported by valid consideration. Any agreement which is to be supported by the law, which is to be enforceable, should have some valid consideration. Remember, wherever I'm underlining, right, this word should be there in your answer. An agreement without consideration is void. Very important. An agreement without consideration is void. A gratuitous promise may form subject to moral obligation. See, if you are getting anything free, that does not have any respect and no value, right? So, a gratuitous promise, the promise which is gratuitous in nature, right? Gratuitous promise may form subject to a moral obligation and may bind in honor, right? May bind in honor, but it does not cause a legal responsibility, right? So guys, this is the way you have to remember. No consideration, no contract, a general rule. However, section 25 of the Indian Contract Act 1872, what it says, provides some exception to this rule. Section 25 of the Indian Contract Act says there are certain exceptions to this rule, where agreement without consideration will be valid and binding, right? Agreement without consideration will be valid and binding. These exceptions, where are the agreement made on account of natural love and affections? Here also we don't have, because especially social agreement is applied. Compensation for the service of voluntary retirement rendered, promise to pay time or debt, right? A contract of agency, completed gift, bailment. So these all cases where we can say that no consideration, no contract is applicable. See, what it says is that section 25 of the Indian Contract Act 1872 provides some exception to this rule. Which rule, bacho? Which rule? A gratuitous payment, gratuitous promise may form subject to moral obligation and may bind in honor, but does not cause legal responsibility. No consideration to no contract is general rule. However, section 25 of the Indian Contract Act 1872 provide some exceptions to this rule. Which rule, bacha? No consideration, no contract. Okay? Some exceptions there, except bit 2. So, where the agreement without consideration will be valid and binding, these exceptions are as follows. Got it? First is what, sir? First is, my dear student, first is agreement made on account of natural love and affections. Our mother, right? For our kids, right? For our parents, we do so many supporting, right? So provided, section 25(1) provides that if an agreement is in writing, see, remember, if an agreement is in writing, second, registered under the law, if they have registered under the law, made an account of natural love of affection, right? If an agreement is in writing, registered under the law, made on account of natural love and affection between the parties standing in a near relation to each other, it will be enforceable at a law even if there is a no consideration. Got it? Got it, बच्चों? अर्थ आगे दिया? अर्थ आगे दिया बच्चों? So, thus, where A form a natural love and affection, promised to give his son B 10,000 in writing and registered, this is a valid contract, we can say that. This is your valid contract, बच्चों. अर्थ आगे दिया? Understood? Understood, बच्चों? So, second case, compensation for service voluntary rendered, means if you have done any services, like in case of if you just go to the railway station where coolie voluntarily they come and they lift their luggage, right? So there also this. So provides that section 25 subsection 2 provides that something which the promiser was legally compelled to do, and promiser was existence at the time when the act was done, whether he was competent to the contract or not. The promiser must agree now and compensate the promise. Thus, when A finds B, pursue and give it a purse, and give it back to him, and B promise to give A 50. This is a valid contract. This is a valid contract. Next, promise to pay time bar debt. What is time bar debt, bacho? The debt supposed to be paid has been over because of insolvency and all. So where there is an agreement made in writing and signed by the debtors or by his agent to pay wholly or a part of time bar debt, the agreement is valid and binding even though there is a no consideration. If A owes B 1000 but debt is lapsed due to time bar and A further makes a writing promise to pay 500 rupees on account if this debt is if that of this the debt, it constitutes a valid contract, right? Time bar go le barta. Next answer iga. Next, a contract of agency. No consideration is necessary to create any kind of agency here. So compelled gift. A completed gift, not compelled, this completed gift needs no consideration. If somebody is gifting you means that required no consideration. Thus, if a person transfers some property by duly writing and registered deed as a gift, he cannot claim back the property subsequently on the ground of lack of consideration. Right? And the last, bailment. No consideration is required to effect the contract of bailment here. Now, father promise. Okay, we'll go with the case here. But your father promises. Guys, you have to remember all these points, my dear student. All these points you have to remember this. Understood? Understood, my dear student? Any doubts you have? Is I'm fast or okay? Because we are doing revision, right? So this notes and all kalsani. Doubt idea? Hey Rima. Doubt idea Indra? Nan explain madinilla madilla. Can you proceed, bacho? No doubt. Chalo. Father promised to pay his son a sum of rupee 1 lakh if son passed CA examination in the first attempt. Then the son passed examination in the first attempt, but father fails to pay amount as promised. Son file a case for recovery of the amount. State along with the reason whether son can recover the amount under the Indian Contract Act. Yes, he can. Yes, he can. How, sir? Nodi. Section 10 of the form valid contract, there should be a intention to create legal relationship between the parties. Agreement of the social in nature or domestic in nature do not contemplate legal relationship. As such, are not a contract at all. Here, it is a social in nature. Father and son is a social in nature. Correct? If there is an agreement between social, father and son, right, it cannot have a contract, which can be enforced. So this principle has been laid down in case of Balfour versus Balfour. Further, to create a contract, it must be supported by some consideration. So, yeah, there is some consideration. A contract without consideration is void ab initio, right? So, in the above case, father promised to pay rupees 1 lakh to his son if he passed his CA exam at first attempt. The son passed the exam, but father fails to pay his son money. In this contract, there was no legal relation between father and son, as it was domestic agreement. So, also there is no consideration from son to his father, and so the contract also lacks the consideration. According to applying the above provision of the case decision, in this case, the son cannot recover the amount of 1 lakh rupees because on the ground of social agreement. On the ground of social agreement, he cannot claim it. Bacha. Understood? Understood, bacho? Understood? Hidama, Priyanka, Archana. Understood, my dear student? Big Henry. No doubt. Are you there or not? Yes, sir. Archana, ಏನತ್ತಮ್ಮ ಅರ್ಥ ನಿಮಗೆ? Next. Ramesh promised to pay 50,000 to his wife, Mr. Lali, so that she can spend the sum on her 30th birthday. Mrs. Lali insisted her husband to make a written agreement, and agreement was registered. Okay, very important, under the law. Now, Mr. Ramesh fails to pay the specified amount on her birthday, and Lali wants to file a suit against Mr. Ramesh and recover the promised amount. Referring to the applicable promise of the Indian Contract Act, advise whether Lali will succeed. That Lali, Bacho, here they have done a agreement that has been, in the previous case there was no valid agreement here, right? But here it is, they have done, it is agreement, written agreement. So if it is written agreement, as per the provision of the Indian Contract Act 1872, to make a valid contract, it must be supported by consideration and must intended to create legal relationship. The court in the case of Balfour versus Balfour held that domestic or social agreement do not create legal relationship. Further, contract which is not supported by consideration is void ab initio. So, however, section 25 lays down the case where the contract without consideration may be formed, shall be binding on the party, right? Hodula. So, in this case where the contract is in writing, registered under the law, made on account of natural love and affection between the parties standing in near relation to each other, it will be enforceable at the law even there is a no consideration. Means for any contract, remember bacho, remember, for any contract, if there is any in writing, registered under the law, made under the natural love and affections, right, between the parties standing near relation to each other, yes bacho, they can be enforceable, right? In the above case, Mr. Ramesh promised to give his wife a sum of 30,000 for his own for her birthday. The wife of Mr. Lali got promise in written and got a registered. The contract, though not supported by consideration, was made on account of love and affection and was writing and was registered. Hence, the contract between Ramesh and wife Lali is valid and enforceable. Thus, Mrs. Lali will sue Ramesh and she will succeed here. Understood? Understood, my dear student? Tell me fast. Tell me fast, bachcho. Oh my God, we have so many guys. I should take one marathon class, bacha. Seriously, 1 hour class won't be work here. Next. Catering. Miss Ram Lal Birla was big businessman. Okay? Miss Ram Lal Birla was big businessman of a city, Pune, having 2 sons, 1 married daughter, 2 sons, total 3 kids he has, 2 sons and 1 married daughter. He decided to give his 1 house to his daughter. For this purpose, he called his lawyer at his house and made a written document for such gift. The lawyer advised him to get a transfer document properly registered. When they both were going to the registration of document, they met with an accident and both of them died. Later, his daughter found the document and claimed the house on the basis of the document. Explain whether she can get the house as a gift under the Indian Contract Act 1872 because two sons are not ready to give his property to daughter. Bachcho, remember one thing. If any contract which provides agreement made without consideration is valid, but it should be expressed in writing, registered under the law, right? For time being in force, and it should be made in the nature of love and affection between the parties standing in the near and real relation to each other, right? In the instant, Mr. Ram Lal Birla decided to gift his one house to his daughter. He had made a writing document for that purpose, but while going to the registration, they have not done the registration of the document. They met with an accident and both of them had died, the lawyer and this one. The later his daughter found the document and claimed the house on the basis of that document. But though the transfer of house was made in the account of now love and natural affection between the parties standing in real relation to each other, written bond, written but not registered. It is not registered. So hence this transfer is not enforceable and his daughter cannot get his gift. अर्थ आಗಿದೆ? Understood? Understood बच्चों? Yes or no? Yes or no? Tell me fast. No doubt? No doubt, my dear student. ठीक है? So बच्चों, oh my god. So I just want to end here. Head Rama. तीन नंबर दो. अर्थ आगिದೆಯಾ? So I just want to end the class now here. Yeah, evening also I want to take somewhere at 9 o'clock. I'll take the law. 9:30. I'll back and I'll take one more class. Okay na? Pushpalata. Idella discuss mana. Right? We'll discuss all this and we'll finish. Okay, guys. So this class YouTube and you can watch an application also. Chalo guys, bye bye. We have guys total is 70 alwai though. So still we have we'll finish this by Sunday. We'll finish this, bacha. I want to finish. अरे कितने हैं रे बाबा? Still we have close to 200 pages, right? So guys, yeah, definitely we will cover that, not a problem. So 22nd we have by 30 तनका इधर मुझे सी law sale of the course also will finish that now. ठीक है? चलो guys, bye bye. We'll catch you in the next class.